Welcome to Public Legal Information. Today we have a special guest speaker named Dania and Majid, a staff lawyer from Advocacy Center for Tenants, Ontario. She will be focusing on tenants' rights during COVID-19. Welcome, Dania.
Thanks for having me.
Can you tell us about ACTO and the work that you do?
So as many people know, there are community legal clinics that are located all across the province that address the local legal needs of their communities. And then there's also another range of clinics called specialty clinics, and those focus on a particular area of law and have a province-wide mandate. So the Advocacy Center for Tenants Ontario, otherwise known as ACTO, is one of those specialty clinics, and we're focused on housing law. So ACTO doesn't represent individual tenants with their housing matters, but so if a tenant has a housing issue, they should go to their local clinic for help. But what we do is we run the Tenant Duty Council program, which is a program of legal workers stationed at different landlord and tenant board locations, which are now virtual locations. And tenants can ask to speak with Tenant Duty Council before their hearing and get some advice, on their matters. In addition to that, we, as a specialty clinic, we also work on systemic work. So that is work that is focused on protecting and advancing the rights of low-income tenants. So we do that at many levels, and that includes, organizing campaigns. It could be pushing for access to justice improvements at the landlord and tenant board. It might be law reform initiatives at different levels of government, to make sure that we get laws and policies that protect tenants. And if necessary, we will go to court to ensure tenant rights are upheld. So what we do in this work is we work very closely with our colleagues in the clinic system to do this work and make sure all their local experiences are reflected in our work. And we will also work very closely with our colleagues in the clinic system to provide them with educational resources and other legal supports to assist them to do their work, that they are doing in their local clinics. So in many cases, we will use actually all these methods to push. We'll use them and work on they come together to used to be pushed for a particular change. So we don't do these types of things in isolation. They need to work together with tenants and clinic workers and lawyers all coming together to push for change. So one example of that, it was the work that we all did together on the National Housing Strategy and making sure that housing as a human right is protected and recognized in legislation. Most recently, ACTO has been doing a lot of work around trying to protect tenant rights during the pandemic. So this includes launching public campaigns and media campaigns, preparing extensive submissions to the provincial government and to the landlord and tenant board with our concerns about Bill 184, the eviction moratorium, the reopening of the landlord and tenant board. And we're also in court, trying to bring back the eviction moratorium. And we're working with clinics across the province to make sure that the landlord and tenant board understands the issues that tenants are facing at the remote hearings. So it's a multi-pronged approach, but it's definitely something we need to do. Our work involves tenants and the clinic system in its entirety.
Many tenants are struggling to pay rent and have a fear of eviction during this tough time. Can you please tell us about tenants' rights and some of the policy changes? What should tenants know during COVID-19?
Okay, so why don't I start with a small piece of good news. Bill 204 was recently passed by the government, and it has brought in a rent freeze for the year 2021. So this means any rent increase that is supposed to take effect in 2021, in the calendar year of 2021, is void. So even if you get the notice in 2020, if that goes into effect, the rent increase goes into effect into 2021, it's void. And the other good news with this is that the rent freeze on rent increases also includes tenants who are in rent geared to income housing, and those units that are not covered by rent control. So those are units that were first inhabited after November 2018. Unfortunately, above guideline increases for many capital expenditures are still allowed to proceed. And now these are moving towards a written hearing at the board. So if tenants want to challenge that, that's going to be through a written hearing. So then the not so great news, as people might have been hearing in the news, the eviction moratorium was lifted at the end of July, and the landlord and tenant board is now open for all remote hearings. So it's not just the emergency hearings. Everything is now being heard, including eviction applications. And enforcement by the sheriff has also resumed. So people are now being evicted during the pandemic. So it's definitely important, if tenants do have a legal issue, it's good for them to get legal advice from their local clinic as soon as possible. The other thing that, is also sort of a source of not so great news for tenants is the recent changes brought by Bill 184. These are changes to the Residential Tenancies Act. Now, these changes were proposed before the pandemic. However, they are now being used during the pandemic to clear the backlog at the board, the backlog of applications at the board. But the one thing that's important to remember is that, under COVID, under the pandemic, tenants and landlords' rights and responsibilities still remain under the RTA. They have not changed. They have not been suspended. So, for example, tenants are still required to pay their rent, and landlords are still required to take care of repairs, keep the complex clean, respect tenant privacy rights, as an example of some of their responsibilities. So nothing has changed with, COVID or Bill 184. But Bill 184 has made some changes to the RTA that tenants should be aware of, because it changes a little bit of the procedural things that that tenants are used to. So one big one, especially as it relates to arrears, and I'll focus on the arrears because rent is the biggest concern right now. Pre-pandemic, a tenant and landlord could resolve their L1 arrear application with the help of a professional mediator at the board, at the hearing, to avoid an eviction. So now, because everything's moved remotely, you can request a mediator to assist you on the day of the hearing, or even before the hearing, but you are probably not going to get one anytime soon. So instead, what the government did, especially by passing Bill 184, the government and the board are now expecting tenants and landlords to negotiate repayment agreements on their own after the L1 application is filed and before the matter goes to a hearing. And this negotiation is now without the assistance of a mediator. So the thing that tenants need to be concerned with in this regard is that Bill 184 changed Section 206 of the Residential Tenancies Act. And that was the provision that governed repayment plans that are done before the hearing, just between the landlord and the tenant without a mediator. So that clause has been changed. And it now allows something called a Section 78 clause to be inserted into those agreements negotiated outside of the board. The concern is Section 78 clause means that a landlord can evict a tenant without notice or without a hearing if the tenant misses a payment from the repayment plan, even if it's by $1 or a day. And this is what we call a fast track eviction. So for this very reason, tenants should never sign a repayment plan they cannot afford. They can provide their own plan as a counter, something that they know they can afford, or they should just wait for their hearing to happen, go to the board, tell their side of the story, explain any, reasons why the eviction shouldn't be granted or should be delayed, any problems with the landlords they might have incurred, or any other issues with the unit, but go and tell your story. Do not sign a repayment plan you know you can't afford, because this can trigger a fast track eviction. If you're unsure, get legal advice. Another change from Bill 184 that tenants should be aware of is that tenants now have to give 5 days written notice to the landlord if they plan to raise any issues under Section 82. Now, Section 82 is the section that allows tenants to bring up their own issues if they are having an arrears hearing with the landlord. So usually these are issues related to unresolved repair issues, any harassment issues, or any other sort of interference with reasonable enjoyment of their unit by the landlord or by the agent, not just the landlord. So in the past, there wasn't a requirement for the advance notice. Now the Bill 184 has changed the Residential Tenancies Act, and now the tenant has to give advance notice if they want to bring up these issues. And it's important to think about this very seriously, because if you bring up these advance issues at your arrears hearings, the repair issues or harassment issues at your arrear hearing, this could actually make the amount of arrears you owe lower, because the tenant is entitled to remedies from these problems, from these issues. So they could get a rent abatement, they can get an order that the repairs be resolved. So Section 82 is a very important right for tenants. So, now if they don't give the landlord advance notice and don't give the landlord, advance copies of the evidence, the board member can, say, you know what, you can't bring these issues here right now, file your own application. So you file a T2 or T6 application to bring these issues. The only concern is that for tenants, it's harder to bring, it might be difficult to fill out the paperwork. And the tenant's going to have to wait now many more months before these issues are resolved, instead of resolving it on the spot. The one thing is, if the tenant doesn't give advance notice, they can try to explain why that is. They could try to, show that the landlord is very well aware of these issues. So if you ever have an issue with the landlord, especially around repairs, communicate in writing, make sure the landlord knows that you are having these issues if you're going to want to bring these issues up later. Again, the other thing is with Section 82, it's always good, if you're going to raise these issues, to be prepared. So it's not necessarily a terrible outcome, except for the fact that it could potentially deny people their opportunity to raise these issues. But a tenant who provides advance notice is going to be and better prepared at the day of the hearing is probably going to be much more successful in raising these issues, and then they won't be barred in the future from ever raising them again. So that's one issue, again, around arrear hearings. Another change from Bill 184 that's also related to arrear hearings is that many times, it's only at the arrear hearings, when they get legal advice, they look through the application, a tenant might realize the rent that they're being charged has been calculated incorrectly, or the notice period given to them was incorrect. Now, Bill 184 has changed that. And if a tenant doesn't challenge that within 12 months, that incorrect rent, or the notice, if the notice period was incorrect, that will be deemed legal. So a tenant only has 12 months. Now, in many cases, with the assistance usually of tenant duty counsel or clinic lawyer, if the rent is incorrect, things get recalculated, there might not even be arrears. However, if you only have that 12-month window now, it's much shorter. So what tenants should do from now on, so when they get their notice of rent increase for 2022, they should read that notice carefully. They should make sure, have they been given 90 days notice before the rent increase takes effect? And second, they should look at the rent amount. Don't assume the rent the landlord listed is the correct amount. Find out what the annual rent increase guideline is for that year, and you do your own calculation to make sure the numbers are correct. And if there is something there's a problem with that number or with the notice period, you need to challenge that, because that is an illegal notice in that regard. So those are the issues really focused on rent arrears. There are some other significant changes to Bill 184, which include minor improvements to the no-fault eviction provisions, including improved compensation, fines, and disclosure requirements. However, unfortunately, many of these provisions that help tenants have yet to be proclaimed.
You have shared very important information with us today. Is there anything else you would like to say to our viewers?
These things are very scary, especially at this time. So if you do get any paperwork from your landlord or from the landlord and tenant board, whether it be a notice or an eviction order, it's really important don't panic, because in truth, in many cases, there are still many steps available to you to prevent and stop that eviction. So don't panic, get legal advice from your local community clinic. You can visit acto.ca or stepstojustice.ca for legal information to know your rights. There might be supports in place to help you get funding and other supports, including calling 311 or speaking to your local counselor. You can always ask for tenant duty counsel at the day of your hearing. And now tenants need to be aware that all hearings are remote. So it means you need to call in or use video conferencing to attend the hearing. So do not miss your hearing if that's the case. If you have technological issues, let the board know, contact them by phone or email, or find someone who can help you log in, or maybe, visit, a community center or some community support that might let you use their technology. If you have accommodation requests, be sure to make those before your remote hearing happens. And make sure you are always prepared. Gather all your evidence, put your issues down in order as the way you want to address them, and make sure that evidence is given to the board and to the landlord in advance so they don't try to dismiss your matter. You also have the right to raise Section 83 arguments at your hearing, which means you tell your story, tell the circumstances about why you shouldn't be evicted, or problem behaviors with the landlord. But there are ways to delay an eviction, and if you come up with the money, that eviction order could be void before the sheriff comes. If there's a problem with the order, there's also options of filing a request for review with the board. But again, this is about you telling your story at the hearing, and accessing the legal resources that are out there to help you do that. So yeah, those are a few helpful hints.
Thank you, Dania, for your time. We appreciate all the work you do and your commitment to keep tenants safe in Ontario. Thank you for watching. Stay tuned for the next video. Be informed and remain safe.